Thanks for making it to Veterans Info Tap. I'm glad you made it. Are you really protected? Is there protections in place regarding your VA compensation, the rating itself, the actual percentage, as well as the service connection piece? There are actually two different protections in place at different levels regarding both of those things. The service connection, protecting that connection. And there are protections in place for the actual rating that you receive. Now, there's also, in addition, protections against any schedule of rating changes. So if the VA changes a rating schedule, there's also protections there. Now, does that mean that the VA is going to, I guess, follow through with all those protections? Not necessarily. They don't have the systems in place to really run all those checks and balances, and we as veterans like to file 1,000 claims to try to get over that finish line. So we're constantly changing our own demographic within the VA system. Now, I would like to think, and again, I don't fully know. I'm sure that some of you do. My thought is that there is obviously, in my opinion, a human aspect to some of the, I guess, failures within the VA's system with regard to erroneously calling for examinations or proposing reductions and that type of stuff, even if they shouldn't happen. So I wanted to dive into it because here's the thing. If you don't know that there are legal protections and the VA does something that they shouldn't, you just throw your shoulders up and go, well, that sucks, I hate the VA, and you move on. But if you know that the VA is wrong, now you have a course of action and you know what you need to do, and you have the evidence that you need to correct it. Hey, VA, you weren't supposed to do it. Here's where it says it in the law, and you can then go about it however which way you want. Contact a veteran service rep to help undo it. An accredited representative, go to a claims agent, go to an attorney, whatever you think you need to do. But you need to be armed with at least knowing what's out there. So with that, I'm going to jump into these protections with you. And for those that don't know, I started a combined co-host channel. That channel is called Veterans Daily, and I'll put that in the comments somewhere and in the description. Veterans Daily is that channel. It's a co-hosted channel with Clay from the Civ Div. And we go back and forth on various topics and give a little more insight and have some actual dialogue regarding things that are important to all of us, right? So in any case, let's jump into it here. Hit the thumbs up, subscribe, share with a friend, all that good stuff. All right, so let's first start. Let me think. How do I want to do this? I'm going to go with the examinations first. So examinations are important because if the VA calls for a re-examination and you show that you're better, or they think you are better, then what happens is they will propose a reduction. So it's important to understand this aspect of the VA kind of disability claim process. So you file your claim, everything's good, you go to your C&P exam, that turned out fine, and everything goes to back to the VBA. The rater ends up assigning you your rating. You're rated at whatever. We'll say you're rated 60% for GERD, maximum, right? Maximum 60% for GERD, but you were recently recently diagnosed for it. You don't have like this long documented, right? Because that's important. It's all evidence. So you don't have this long documented history. So the VA may throw out a future examination date. Okay. Anytime you have a future examination date, this is a potential reduction if your condition betters. Now, look, I get it. In some cases, we would definitely rather be better than get $500 from the VA or whatever it is, right? So, but a lot of cases you don't get better, but you don't go to the doctor and you're not being seen and you're just dealing with it, and then you don't know how to explain it, and then you're there and then they go, oh, you're magically better, and then they reduce you when you shouldn't have been reduced. So kind of keep that in mind as well. So now you have this re-examination that's coming up, and again, that could turn south for you. Now, there are some protections for you with regard to future examinations. And I'm going to read through this reexaminations portion of the Code of Federal Regulations, the CFR. Everybody likes to, I don't know. I don't really care. I mean, the books are wherever, right there. Those are CFRs. They're super fat. So the different colors mean different years for any changes, because the VA is constantly changing how they do things. So let's jump into this. This is, I'm reading it off the CFR online, the eCFR, because it's much easier than going through those. So, all right, let's jump through it here. Reexaminations. Now, look, hang on with me. I already know we're at 5 minutes, but this is super important information because we all worked very hard to get our examinations or what have you in place, our service connections. So the reexaminations, if you can avoid them, would be a good thing. So reexaminations include periods of hospitalization, observation. They will be requested whenever VA determines there is a need to verify either continued existence or the current severity of a disability. Okay, so that's as far as I'm going to read into that first piece. So they're going to do that, and that's what will happen after the C&P exam if they think there's a chance that your condition could better. Now, how do we avoid it? So I'm skipping down here. No periodic future examinations will be requested, period. In service-connected cases, no periodic re-examination will be scheduled, okay? So none will be requested and none will be scheduled. And then it has a list of, 6 things, okay? I've done videos on this in the past, but seems like people are starting to get a little bit antsy and want to know this material again. So the first one's my favorite. This is number 1, when the disability is established as static. Okay, what that means is that your doctor has basically stated, and the VA concedes, or the C&P examiner even states it, that look, based on all the evidence or the information that we have, this type of a condition is a static, meaning it will never change. It most likely will just get worse in time. It will never get better type of a condition. And if you're deemed static, the VA will not request those future exams, which means if there's no future exam, then why would they're not going to reduce you, because they have nothing to reduce you from, right? Because evidence-wise. So that is a super safe place to be, static. Also, being static or not having future exams, so any one of these buckets, put you into the bucket of permanent and total. So as long as your conditions that take you to 100% are not requiring future exams, they will make you permanent and total. So this is an important piece. So static. Number 2, when the findings and symptoms are shown by examination scheduled in paragraph B2(1) or I of this section or other examinations, and hospital records have persisted without material improvement for a period of 5 years or more. So in other words, you've now had the condition for 5 years, and any examinations or hospital reports or medical information all show that you are static, is what they're really saying. They're just saying it in a different way. But you have proven over the past 5 years that there has been no material change in your condition. Therefore, the VA goes, well, then you're static, right? Now, next is number 3, where the disability from disease is permanent in character and of such nature that there is no likelihood of improvement. So there's certain diseases or ailments or conditions or what have you that are, look, that's what it is, and that's where you are. There is going to be zero change for you. That's not going to go away. So that would be a safe, no re-examination type of a condition. Number 4, this is the 55-year-old rule that many of you are aware of. In cases of veterans over 55 years of age, except under unusual circumstances, whatever that means. So, unusual means not often, right? Number 5, when the rating is prescribed scheduled minimum rating. So in other words, if the rating schedule calls for if you have a X condition and there is a 10%, a 30%, and a 50% rating option, and they rate you at 10%, well, they've already service connected you for that condition, which means they have to give you an assigned rating. If they gave you the lowest one, there's no need for a re-examination in the future because they can't lower you lower than the lowest rating that's on there. So that's what they're saying there. If you're at the lowest rating level for that condition, they're not going to have you come in for a re-examination. It's a waste of resource. So moving on, number 6, this is the last one here, where a combined disability evaluation would not affect or not be affected. The combined disability evaluation would not be affected if the future examination should result in reduced evaluation for one or more conditions. So if you have multiple conditions, and I'll give myself as the example. So I'm at 100% with all of my conditions taking away one. I'm still 100%. All of my conditions are static and take me to that 100%. So I'm 100% permanent in total. I have one other condition, and it's actually GERD. And they put out for a future exam, but then they realized that even if they made my GERD 0, I'd still be 100% permanent in total, so there's no need. Now, there's a lot more to that story and the way that it all worked out, because really I wasn't 100%. I was 100% with GERD, then I got another condition that made me 100% permanent in total. Then I didn't need GERD anymore, and then they eliminated that future exam. So anyway, that's the whole point of that, is that if it doesn't change your overall rating, then why would they reevaluate you for that condition if it doesn't change your overall rating? Especially if you have a bunch of statics and you have one outlier that has a future exam. If it doesn't change your overall, they don't care. So these are the protections with regard to examinations, which we all know re-examinations could lead to reductions. So we talked about the 5-year rule in this, where if you show no material improvement over 5 years, then you get that protection. We talked about the 55-year-old rule in there, that if you're over 55 years of age, there should not be a re-examination except for under unusual circumstances. Then we have on here, let's go to the 10-year rule. I have that somewhere. All right. So in the CFR, again, the Code of Federal Regulations, and, blah, 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 3.957 service connection. So there's a little paragraph here, and I'm just going to read that to you on the 10-year rule. And explain it to you so you understand what it means. This rule protects your service connection, meaning that the VA can't come in and go, it's not service connected anymore, and they're going to take it away from you, right? So service connection being service connected for a condition, right? So your service connection for any disability or death granted or continued under, I'm guessing like a death benefit granted or continued under Title 38 USC, which has been in effect for 10 years or more. So go back to the service connected piece. For 10 years or more, will not be severed except upon showing that the original grant was based on fraud, or is clearly shown from military records that the person concerned did not have the prerequisite service or character of discharge. Okay, so the 10-year period will be computed from the effective date of the Department of Veterans Affairs finding of service connection to the effective date of the rating decision. So basically what they're saying here is, from the date you got service connected for your condition, once 10 years runs, you're golden as far as they'll never take that service connection away from you. Now, you could get increases or decreases along that way. It doesn't matter. What they're looking for is how long have you had that service connection. And again, this is protecting your service connected condition. So once you hit the 10-year mark, now they cannot take away your service connection for anything except for fraud or that you didn't have the correct type of service or discharge. So that is good to know. Now let's jump over to the 20-year rule, which everybody loves to talk about. So the 20-year rule, again, in the CFR, right? So the Code of Federal Regulations for Veterans Affairs stuff. So it's 38 CFR. There's a few different things here, and I'm just going to read. This is actually like how many? It's 7 pages, and it's 1,400 words broken down into different kind of sections and change dates. So I'm not going to read this whole thing to you, but I am going to read off a couple pieces regarding the 20-year, and one of my favorite pieces about the 20-year rule, because the VA does make mistakes, and sometimes those mistakes can actually be in our favor, which is kind of funny when it comes to the VA. So let's take a look here. I'm pulling it up right now. There we go. All right. So under CFR, right, 38 CFR 3.951 and 38 CFR or 38 CFR 3.952, exercise care to avoid. So this is kind of like the rule book for the VA is kind of how you have to view the CFR, right? So it's kind of the rule book for them. So exercise care to avoid violation of the provisions of 38 CFR 3.951 and 38 CFR 3.952 for compensation and pension disability benefits. Do not reduce an individual disability evaluation that has been continuously rated at or above the current level for 20 years or more, except in the case of fraud. Okay, so what they're looking at here is from the current rating. Okay, so it says, again, let's read it. Do not reduce an individual disability evaluation that has been continuously rated at or above the current level. So if you're rated at 50% now, and you've been rated higher than that in the past, but you're at 50, they're going to take that into consideration, right? Because it's rated at or above the current level for at least 20 years. So it says to measure the 20-year period of that from the earliest effective date of the combined or individual evaluations. So oftentimes it's going to be the individual evaluations. It says here, for purposes of determining whether benefits were received for a continuous period of 20 years, include periods during which the which recoupment or deduction applied to an award. So they're basically, again, it's the rule book. But another piece here, it states, do not reduce benefits when a combined evaluation has been in effect for 20 years or more, except in the case of fraud. Both the individual evaluations and the combined evaluation are protected under 38 CFR 3.951B, even if erroneously assigned. This one I love. If the VA screws up, and let's say that whatever, it was supposed to be your right leg, but for some reason they said it was your left leg, was all messed up, and they gave you ratings on that. You're and that stuck for 20 years, and nobody ever said anything, and you never caught it, and you didn't notice it. Now they can't take it away. It's on their fault, unless you were in a fraudulent situation, with a VA worker or something like that, and that was found out, sure. But if it was just some sort of a mistake that they made, then they go, oh, well, we'll just have to eat that because it's been 20 years. So that is fantastic. They also have the combined rating as well, which is really good explanation here. So the example is no rating action is warranted no rating action is warranted to reduce the erroneous 50% in this example combined evaluation to the proper 40% combined evaluation in a case where, here we go, 2 service-connected conditions, right, disabilities, have been evaluated at 30% and 20% disabling respectively. Okay, so a 30% and a 20%. Now, on its face, it looks like 50. However, 30%, the VA with the VA funny math, if that's your only 2 conditions, for an example, you have 30%. Well, that's 30% bad. Then the VA goes, well, you're still 70% good. Then they're going to take your next 20% rating and go, okay, well, 20% of your 70% good is 14. They're going to add the 14 to your 30% bad. Now you're 44% bad. That's your overall rating, 44. They're going to round you to the nearest 10, which is down to the 40. So your correct rating would be a 40%. But in this example, they accidentally put you at a 50% rating. So it states here in the next bullet, an improperly assigned combined degree of 50% has been in effect for 20 years or more. They will not change it. They will leave it there regardless. So that's one of my favorite rules about the 20-year rule, or within the 20-year rule. Next thing here, it states that that rating evaluations cannot be reduced solely because of a change to the rating schedule. So we talked about the re-examination protections. We talked about the rating service connection protection at the 10 years. We talked about your overall at the 20-year. And then now we're talking about protections regarding changes to the rating schedule, which that's kind of been a hot topic, folks talking about the changes to the rating schedule proposed, right? I've talked about it. Everybody's talked about it. So what kind of protections are there? So we'll give you the actual numbers here. So protected evaluations under 38 CFR 3.951 and 38 CFR 3.952 continued to letter G, protecting against rating schedule changes. Public Law 102-86 states that a rating evaluation cannot be reduced solely because of a change to the rating schedule subsequent to August 13, 1991. However, 38 CFR 3.952 protects rating evaluations under the 1925 rating schedule, which were the basis of compensation on April 1st, 1946. Note, evaluations in effect when previous changes to the 1945 rating schedule occurred are not protected by that public law. And then it says here, for more information regarding the preservation of disability evaluations after rating schedule changes, you can also dive in to, again, 38 CFR 3.951 alpha and then the 38 USC 1155. I'm not going to dive into those. I'm just bringing it to your awareness that public law does state that the rating evaluation can not be reduced solely because of a change to the rating schedule. So important to know. With that, we'll leave it there. I really appreciate each and every one of you. I hope that this sheds some light on some things. If you hung on till the end, thank you so much. And I will tell you that the VA does screw up. They mess up, and if they mess up once, it's too many times, right? But the big deal here is that you understand what the actual law is, what the rule book is, what protections are really there for real, right? And then you can actually fight and know where you're protected and know if you're getting bamboozled, right, from the VA. And if you are, you'll have the strength to fight back. So with that, thanks so much for watching. I appreciate you. Have a great one. And remember, if we don't take care of each other, something went wrong.